Good afternoon. Excited to be able to talk to you once again. So I know it's been a little bit of an emotional process going through this. This is not the kind of case that is it's difficult to sit through. And I mentioned the founders, when they created our country, they wanted big decisions to be made by the individuals in our community, right? By us, about what's going to happen within our community. And the role of jurors is paramount to the entire system working. And so in our country, there is special respect given to certain people based on position, not based on who they are, based on the role that they hold. And for you, if you've noticed, you're one of the few positions that we stand for you. Every time you come in, every time you leave, we stand for you, because you are in a role that is so critical. And thank you for your attention during this entire process and for your good work. It's been very clear that you have been very invested in paying attention. So thank you. This is a simple case. I said this at the beginning and opening, that the case is very straightforward about what happened. And if I saw you on the street and we were chatting and I told you that I had a case where a woman had been seriously injured and her husband had been killed because someone decided to get heavily intoxicated and go on a crazy drive through Las Vegas, you'd probably ask me, what happened? What's the story? And I'd tell you that the guy went on kind of a bender for some reason because he had the night off and decided to go do all this crazy stuff. And I'd also tell you that the man that got killed was a wonderful guy, and was a guy that the world is not going to be as good with him being gone, and that it had a major impact on his family and on his wife. And if I told you all that, you'd wonder, why on earth are we here? So why are we here? Now, of course, as I just went through that, I made it a little bit simple, more simple than it is, but not by much. This is a very, very simple case. It's very, very straightforward. And in fact, as we got into the evidence and you saw it and you heard the testimony, it's perhaps even worse than I think that we presented originally. So the story of this case, Defendant Raspberry chooses to become severely intoxicated. Defendant Raspberry chooses to run a red light at 107 miles an hour. And Defendant Raspberry kills a man and shatters a family. So this case is simple, but I've been given some time by the judge, and I'm going to take less than a half hour. But I want to use this time as best I can to go through a few pieces of evidence. But during this, please don't forget about the big picture of what this is. As attorneys, we get really into the very small details of things sometimes and forget the big picture. During this case, the defense has presented some defenses that are not legitimate, that are baseless, that are irrelevant. And I don't want you to be distracted by those. For example, the defense spent their opening talking about medical bills, which are not even part of this trial, not even something you guys have to consider. The cost of wheelchair rentals and funeral flowers, again, not part of anything you have to decide at all, not part of anything you have to think about. All of that stuff's already been decided. You literally don't need to waste a single thought on it. But why, then, was our time wasted with that information? Or they may be trying to make you equate the value of what was really lost here. Life, the enjoyment of life, the pain, the suffering, the grief. Something you are absolutely supposed to be considering. That's part of the decision making. By focusing on things like medical bills, wheelchair rentals, funeral flowers, down to the dollar. And what about the incessant questioning of witnesses? In cross-examination, over and over again. Hey, did you ever drive Nympha over to the therapist? Did you drive her to a psychiatrist? Well, no one's ever claiming that anyone did. But why all of those questions? Are they trying to suggest that Nympha and her family are lying about the grieving, about the grief, about the trauma? Are they suggesting that there's something untruthful about this phobia that shuts Nympha down? Are they trying to suggest in any way that the trauma is not real or not severe because Nympha has relied on her husband as her doctor for her whole life? You saw Nympha, you heard how she is in some ways kind of a shell of who she used to be. This is a strong woman. She was Marshall's equal partner. We heard a lot of really great stuff about Marshall, but Nympha was Marshall's equal partner. She was an in-charge person that knew how to take the lead. Marshall was brilliant, he was. And he was a teddy bear. But the buck stopped with Nympha. When they would go somewhere, Nympha was usually the one that would drive. And for some reason on this day, on October 27th, 2019, Marshall drove. And maybe that has something to do with the phobia. But is there any doubt, based on the evidence, that Nympha's life was shattered by this? The trauma didn't just break her body and take away her ability to walk normally or just live without pain. The trauma impacted her mind so severely that she is literally a prisoner of her own mind. Nympha cannot drive anymore. Now, she can get in a driver's seat, and she can push the pedal for the brake, for the gas. She can turn the steering wheel. She can do that physically. But she can't drive because of the terror that she has. And it would not be safe for others on the road if she did. And she knows that. And so she's done. And even as a passenger, she sometimes has to close her eyes, duck her head, plug her ears just because of sounds outside of the car, just to get by, because it's that bad. There were also some efforts by the defense to create sympathy for Defendant Raspberry related to prison sentences. Defendant Raspberry here, he didn't take really just one life on October 27, 2019. In many ways, he took more than one life. And that's just speaking about the victims that we represent, that we're here about.
Objection, Your Honor. May we approach?
Yes. So, to be clear, there's been talk about how he's going to jail for all this time. And there's a judgment on the verdict that was talked about. And he is going to jail for a while, and it's partly because he killed Marshall and seriously injured Nympha. But it involves the other victims there too. And it involves totally separate drug possession things, right? There's a combination of things that he's doing his time for. And no part of that overlaps with the civil part of the case, dealing with the victims here. And when you go to evaluate the issue of the punitive damages. Look at jury instruction number 26. And that's the one that lays it out. That says what you look at for punitive damages. Now, even in the face of all that he's done, did you see any remorse at all for what he did in his videos? Did you see any remorse for this? Has he actually taken any responsibility for what he has done? Has he really?
What Mr. Raspberry did has already been established, and what everyone knows what Mr. Raspberry did was wrong.
That's true, we do, but let's not pretend that's how it started, right? A lawsuit was filed, an answer was issued, and the answer blamed the plaintiff for causing the crash. The answer blamed third-party defendants, saying that he had no control over them. The answer asked that plaintiff's case be dismissed and that plaintiff be made to pay Mr. Raspberry for the trouble of having to defend himself. Now, that's all over after summary judgment. The excuse for this was that we only have a limited time to answer, we don't know everything, he doesn't know everything, but he was already convicted that it's a boilerplate thing. Does that make it worse or better? You just routinely accuse your victim when they bring a complaint against you. It's just your SOP, standard operating procedure.
No one here is trying to blame the Escobias for anything. Please note that. There will be no evidence to that effect.
8 minutes later.
The evidence will show that she's not ever pursued any kind of like psychiatric or psychological care. She was discharged on November the 5th, 2019. So she's in the hospital for 9 to 10 days, just closer to 10. And she's told to follow up with Dr. Villaluz in 2 weeks. And the records will show that she didn't follow up in 2 weeks.
So, I don't know, maybe that's blame with a little b, right? Instead of a big B. But it was the same kind of blame we saw witness after witness, right? You recall when her daughter was on the stand. And, well, you're a nurse, right? You like force her to get into the treatment because you know she's having these terrors, that she's having these horrible things. Well, I can't get her to, and the blame being put on people totally inappropriately, totally unnecessarily. There was blame. And what about defendant Raspberry? So this is a jury instruction. This is jury instruction number 9. But it's just about credibility and believability of witnesses. We did our best to bring witnesses before you that were credible, that just told you the truth sincerely. They told you what they had experienced, what they believed. And you evaluate them based on their testimony on the stand. In this case, defendant Raspberry, they decided not to have him come. So, with him, you must consider the deposition testimony that was presented, and it's considered the same way as though he had been right here in trial. And so that's what we had to work with. I didn't have a chance to cross-examine him and go over things with you in front of...
Well, I'm going to make an objection, Your Honor. He could have subpoenaed defendant Raspberry to be here.
No, I couldn't.
Yes, you
Actually,
could.
No,
absolutely you could.
Continue on.
Thank you, Your Honor.
For strategic reasons, they chose not to bring him.
Your Honor, may we approach?
In the testimony that we did have, his deposition.
Do you agree with me that while operating a vehicle, it's always important to be in control of that vehicle?
Yes.
Would you agree with me that it's reckless to drive a vehicle while under the influence of alcohol?
Yes.
Would you agree with me that it's reckless to drive a vehicle while under the influence of marijuana?
Yes.
Didn't really want to answer those ones, did he?
Would you agree with me that it's reckless to drive a vehicle while under the influence of ecstasy?
Yes.
Would you agree with me that it's reckless to drive a vehicle at over double the posted speed limit?
Yes.
Would you agree with me that it's reckless to run a red light?
Yes.
Would you agree with me that all of those things occurred in this crash?
Yes.
But did you accept responsibility or did the court force it on you?
The court forced it on me.
As you sit here today, do you accept responsibility for what happened?
I have no choice.
Why don't you have a choice?
Because I'm here.
Because it's been forced upon you?
Yes.
But there's no denial of what he did. There's no denial of what he has cost the Escobias.
Do you agree that this accident was your fault?
No.
No denial. No denial about what he did. It's not his fault. No denial about what he cost the Escobias. I don't think that's the message you've been getting from the defense.
Can you explain to me what your understanding is of how the crash occurred?
Car was traveling west, entering into Rainbow South, and collided with Mr. Escobia.
And when you say a car was traveling, what car was that?
The Toyota Avalon.
Is that your car?
Yes.
Were you driving that car?
I don't know.
Would you agree that the driver of that vehicle should be punished?
Yes.
And would you agree that the conduct of that driver was despicable?
Yes.
But my understanding is that at the criminal trial there were witnesses that testified that you were extricated from the driver's seat of your vehicle. Is that correct?
Correct?
But you don't accept that you were the driver of that vehicle?
Right.
Okay. And you don't accept that your conduct caused this crash as the driver of that vehicle?
Right.
Nobody else in the car. He has to be cut out of the car from the driver's seat, and he does not accept that he did anything wrong.
What is the basis for your dispute?
I don't drive fast like that. That's not my character. I've never had a speeding ticket. I'm not a reckless person.
Not a reckless person. Doesn't say anything about meth, ecstasy, drinking, and all of those other things that he does before he drives.
You've been drinking prior to the crash?
Yes.
What had you consumed as far as alcoholic beverages prior to the crash?
More than likely tequila and Jaeger.
How much tequila had you consumed prior?
I'm not completely sure.
Can you give me an estimate?
5 drinks.
Would that be 5 shots?
No, probably 5 margaritas.
Can you give me an estimate of how much Jaeger you had drinking prior to the crash?
Maybe 3 shots.
Any other impairing or intoxicating substances or beverages that you consumed in the 12 hours prior to this crash?
Marijuana.
How much marijuana had you consumed?
A few blunts.
Would you typically drive after consuming marijuana?
Yes.
In the 12 hours prior to the crash, had you taken any illegal or illicit drugs or substances?
Yes.
What did you take in?
Ecstasy.
Was there a reason that you were doing all of this this particular night?
It was the first time I was off on a weekend in a while.
So what's the cost of his little rampage, his little fun weekend? But the real cost.
Just been handed 2 photographs. Do you recognize the people in the first photograph?
Yes.
Who are those?
Come on, Escobia and Marcel.
Okay. And who are they?
People selling me.
Can you imagine? He knows he's killed a man, right? He knows he's shattered their lives. And he looks at their picture like that. And he knows them as the people who are suing him.
Who are they besides the people that are suing you? Were they involved in the crash?
Yes.
Okay. Do you know anything about them?
The Filipino?
Okay. Anything else?
No.
Okay.
So truly accepting responsibility requires full value of the harms and losses being recognized. From the beginning, the defense has tried to get credit for accepting responsibility without taking responsibility. And that's why we're here. We need you to balance the harms. The full value of what was wrongfully taken, on the one hand, needs to be fully recognized in the award on the other. This is the instruction number 8 that says insurance is not to be considered. The reality is how, who, when, what, if anything gets paid is not part of the deliberation, is not part of the process. To some degree, you need to trust that things will work out the way, because you're in this box right here, right now. And you decide the full and fair value of what the harms and losses are. And you state that in truth on your verdict to balance what has been wrongfully taken on the other side. When you go back to the jury room, if one of your fellow jurors says something to the effect of, what happened here is so bad that it's more money than any one person should receive, or it's more than Marshall would have made in a lifetime, or something like that, remind that juror that that's not what we're supposed to be doing. That would be a violation of our oath. What we have to do is fully value what was wrongfully taken and balance that with a verdict that speaks to that. When you go back to the jury room, if a fellow juror says something like, the defense kept talking about Defendant Raspberry doing a bunch of time or something, and so I don't want to do punitive damages or something based on that. Let them know. Go to the jury instruction that I mentioned. 26, say
Your Honor,
no.
I make an objection. We're not into the punitive phase of the case. Thank you.
Continue on, Your Honor. Thank you. So, and then you go ahead and you check that box for punitive damages, yes, because it is super clear under the jury instruction at issue that punitive damages are appropriate here. And in addition, it's important to note you haven't been provided any information about Defendant Raspberry's financial condition. Nothing. They have not shown any degree of poverty, any degree of wealth. Doesn't matter. It's not part of your consideration in it. When you go back to the jury room, if a fellow juror says to you, excuse me. All right. So how do you value a case like this? What is the full value of what was wrongfully taken? It's, if our client was Bill Gates or, you know, Elon Musk or somebody worth $100 billion, how would her pain, her loss be valued? How would it be? And the reality is, we know that in daily life, judgments are made and people are treated differently out in the world than they deserve. And maybe the valuation would be different in those circumstances. But here, this is one place where everyone is equal, and that my client's harms should be valued according to what they are. What is the full and fair value that a reasonable person would have to receive to take on what has been taken? And at least it's supposed to be. Right? This is supposed to be a place where we're all equal. So this is a painting that I really like. I don't know a lot about art, but I took a couple of humanities courses when I was in college, and I fell in love with Van Gogh and Rembrandt and kind of some cool things that some of their paintings. And this painting is by Gustav Klimt, and my wife and my daughters, I have a couple of teenage daughters, and they can paint, right? They can just, they'll break out a canvas and they'll paint. It's just beautiful. And it really is amazing. And I have tried myself. And I do not have the gift. It's not to say that if I didn't work really hard for many years, I couldn't become good at it. But man, I am not naturally good at it. And it's really amazing to me when someone can do something that's beautiful. Now, this painting, I like it. I'm not sure why, but I don't know why it's worth what it is apparently worth. Because in 2013...
Your Honor, I need to make an objection. May we approach?
So this painting was sold in 2013 for $222 million, right? And if we were here today about painting, right? We're here and there was a painting and somebody slashed it, somebody destroyed the painting, tore that canvas open, there would be no hesitation. Everybody would know that the amount is identified. It's been appraised. They know what the valuation has been, $222 million. It is what it is. And what about the canvas of a person's life? How do we value that? How do we value that? Where do we place that valuation? So the law helps us. It tries to do the best it can to help us arrive at a full and fair valuation. And so this is jury instruction 18. And I am sorry, I thought that it would be more clear. Can you see it okay? Okay, so it says, you will take into consideration. So it gives you kind of the mandate of what you have to take into consideration, and that you need to find a sum of money to fairly compensate for these items: physical and mental pain, suffering, anguish, disability, and loss of enjoyment of life. And it has two paragraphs there. One is from the time of the crash to the present, and then from the present for the rest of Nympha's life. Okay? And then here's a separate, another one that has additional damages. And so I'm making it bigger so that it can be seen. Loss of probable support, companionship, society, comfort, and consortium. And to make something very clear, loss of probable support, we're talking about emotional, human support. We're not asking for checks or anything like that. So not identifying financial support in any way, okay? This is support as a human, okay? Also, any other facts shown by the evidence indicating what benefits Nympha Escobia might reasonably have been expected to receive from Marshall had he not died, had he lived. Any damages for pain, suffering, disfigurement, or loss of enjoyment of life of Marshall. Any grief or sorrow suffered by Nympha Escobia, and any grief or sorrow reasonably certain to happen in the future. And so this is a big, long list of all of the damages. You don't need to write them all down, but I'm going to go through and I'm going to show you all of them, and then what they've done is they've compressed them onto the verdict form into 5 different groups. So these, 15 or 20 items. So Marshall's physical pain, Marshall's mental suffering, Marshall's disfigurement, loss of enjoyment of life. All of the rest are Nymphas, grief and sorrow, loss of companionship, loss of society, loss of comfort, loss of consortium, physical pain, mental suffering, humiliation or shame, anguish, disability, loss of enjoyment of life. Now, we recommend that in every one of these categories that it be somewhere between $1 million and $10 million. And it is for you to decide what it is. And obviously, these categories are not all equal, right? You've been here, you've seen the evidence. If you were talking about, for the loss of enjoyment of life that Nympha has suffered, what would she have to be paid to go through what she's done? That's a lot different than the humiliation, right? She would deal with the humiliation at some level. The loss of the enjoyment of life from what has happened is a different thing. So here's the verdict form. When you go back and you deliberate, you're going to have this verdict form. It's 2 pages. This is the first page. And here are the categories. So as you can see there, pain, suffering, disfigurement, and loss of enjoyment of life. Those were the first 4 categories there. Then the next one, plaintiff Nympha Escobia's grief, sorrow, loss of companionship. And so they have broken them down into these 5 categories, okay, as groups. This right here is filling it in to $85 million, okay? So we put 20 million, 20 million, 20 million, 10 million, 15 million. We told you from the beginning that we were going to recommend, we thought the appropriate valuation was between $55 and $85 million. This is not to say that we think this is exactly right, okay? This is to say that we think that is an appropriate verdict and that it is for you to determine where it is. And we believe that something between 55 and 85 is appropriate. And I will say, well, as you're going through and you're evaluating it, someone may say, well, I wouldn't accept what happened to them at any price, right? I wouldn't. Are you kidding me? I wouldn't accept. There's no amount of money. There's no amount, right? And if that's how you feel about it, then you know that the numbers that we are talking about are not too high. The full and fair value. And that is not to say that we think you should go higher. It's not. We think that this is the way that will send the right message to fully and fairly compensate. And then the second page, this is all that's on it. One question: does the jury find by clear and convincing evidence that punitive damages should be assessed against defendant Kevin Philip Raspberry? Check yes. And then the foreperson signs and returns the verdict. Like anything else, the worth of anything is based on what someone will pay for it, what someone would have to be paid to give it up. When we take a job, you know, we have jobs, and we hopefully the jobs we do are things that bring us fulfillment, that bring us meaning in our lives. But any job that we have, if it's hard, if it's long, if it's painful, of course, the person doing the work and going through it needs to be paid a fair labor. You wouldn't take the job. And so the valuation of something like this, what would a person have to give up to be able to take this on, is significant. Now, not everyone has a storybook marriage or relationship, right? And we know that. Not everybody does. But sometimes somebody does, right? And it's a thing that should be cherished. And Nympha did. Marshall loved her so much. Marshall convinced her to marry him, even though she didn't believe in marriage. He doted on her because he loved her. They were best friends. They spent all their free time together. When she was getting older and started to worry about her looks, Marshall was there telling her how beautiful she is. When she was afraid, he was there to comfort her. When she wanted to celebrate because something had gone really well, she wanted to do it with Marshall. And at the time of their life where they expected to spend more time together, right? You're going to do a mission in the Philippines and then come back and be with family and really dedicating themselves to the service, the community they cared about, and to each other. He was taken from her unnaturally. Not a situation where somebody offered her something and she got a choice in anything. In fact, he was taken from her very unnaturally and without consent. I've done the best I know how to explain to you why I think that you should award a significant amount in this case. I've tried to help you understand the best I can why this case should be valued and what I think it should be valued at. But what I think is irrelevant. It doesn't matter, and I know that. The only thing that matters is what you guys think. And if you believe in your heart that an amount is different than mine, then you must do what you believe in your heart is right. You must. And of course, we hope that you value what they have been through, what our clients have been through, and that you validate their suffering and send a message based on the evidence in this case that what happened here is not okay, and that the harms and losses in this case are very serious and are highly valued by this community. Thank you.